Vienna Convention on the Law of Treaties. Done at Vienna on May 23, 1969. Part 6 and Part 7, Part 8 and Annex. Part 6. Miscellaneous Provisions. Article 73. Cases of state succession, state responsibility, and outbreak of hostilities. The provisions of the present convention shall not prejudge any question that may arise in regard to a treaty from a succession of states 50 or from the international responsibility of a state or from the outbreak of hostilities between states. Article 74. Diplomatic and consular relations and the conclusion of treaties. The severance or absence of diplomatic or consular relations between two or more states does not prevent the conclusion of treaties between those states. The conclusion of a treaty does not in itself affect the situation in regard to diplomatic or consular relations. Article 75. Case of an aggressor state. The provisions of the present convention are without prejudice to any obligation in relation to a treaty which may arise for an aggressor state in consequence of measures taken in conformity with the Charter of the United Nations with reference to that state's aggression. Part 7. Depositaries, notifications, corrections, and registration. Article 76. Depositaries of treaties. 1. The designation of the depositary of a treaty may be made by the negotiating states, either in the treaty itself or in some other manner. The depositary may be one or more states, an international organization or the chief administrative officer of the organization. 2. The functions of the depositary of a treaty are international in character and the depositary is under an obligation to act impartially in their performance. In particular, the fact that a treaty has not entered into force between certain of the parties or that a difference has appeared between a state and a depositary with regard to the performance of the latter's functions shall not affect that obligation. Article 77. Functions of depositaries. 1. The functions of a depositary, unless otherwise provided in the treaty or agreed by the contracting states, comprise in particular a. Keeping custody of the original text of the treaty and of any full powers delivered to the depositary. b. Preparing certified copies of the original text and preparing any further text of the treaty in such additional languages as may be required by the treaty and transmitting them to the parties and to the states entitled to become parties to the treaty. c. Receiving any signatures to the treaty and receiving and keeping custody of any instruments, notifications, and communications relating to it. d. Examining whether the signature or any instrument, notification, or communication relating to the treaty is in due and proper form and, if need be, bringing the matter to the attention of the state in question. e. Informing the parties and the states entitled to become parties to the treaty of acts, notifications, and communications relating to the treaty. f. Informing the states entitled to become parties to the treaty when the number of signatures or of instruments of ratification, acceptance, approval, or accession required for the entry into force of the treaty has been received or deposited. g. Registering the treaty with the Secretariat of the United Nations. h. Performing the functions specified in other provisions of the present convention. 2. In the event of any difference appearing between a state and the depositary as to the performance of the latter's functions, the depositary shall bring the question to the attention of the signatory states and the contracting states or, where appropriate, of the competent organ of the international organization concerned. Article 78. Notifications and communications. Except as the treaty or the present convention otherwise provide, any notification or communication to be made by any state under the present convention shall a. If there is no depositary, be transmitted direct to the states for which it is intended, or if there is a depositary, to the latter. b. Be considered as having been made by the state in question only upon its receipt by the state to which it was transmitted or, as the case may be, upon its receipt by the depositary. c. If transmitted to a depositary, be considered as received by the state for which it was intended only when the latter state has been informed by the depositary in accordance with Article 77, Paragraph 1, e. Article 79. Correction of errors in texts or in certified copies of treaties. 1. Where, after the authentication of the text of a treaty, the signatory states and the contracting states are agreed that it contains an error, the error shall, unless they decide upon some other means of correction, be corrected. A. By having the appropriate correction made in the text and causing the correction to be annulled by duly authorized representatives. B. By executing or exchanging an instrument or instruments setting out the correction which it has been agreed to make, or C. By executing a corrected text of the whole treaty by the same procedure as in the case of the original text. 2. Where the treaty is one for which there is a depositary, the latter shall notify the signatory states and the contracting states of the error and of the proposal to correct it, and shall specify an appropriate time limit within which objection to the proposed correction may be raised. If, on the expiry of the time limit, A. No objection has been raised, the depositary shall make and initial the correction in the text and shall execute a procès-verbal of the rectification of the text and communicate a copy of it to the parties and to the states entitled to become parties to the treaty. B. An objection has been raised, the depositary shall communicate the objection to the signatory states and to the contracting states. 3. The rules in paragraphs I and II apply also where the text has been authenticated in 2 or more languages and it appears that there is a lack of concordance which the signatory states and the contracting states agree should be corrected. 4. The corrected text replaces the defective text ab initio, unless the signatory states and the contracting states otherwise decide. 5. The correction of the text of a treaty that has been registered shall be notified to the Secretariat of the United Nations. 6. Where an error is discovered in a certified copy of a treaty, the depositary shall execute a procès-verbal specifying the rectification and communicate a copy of it to the signatory states and to the contracting states. Article 80. Registration and publication of treaties. 1. Treaties shall, after their entry into force, be transmitted to the Secretariat of the United Nations for registration or filing and recording, as the case may be, and for publication. 2. The designation of a depositary shall constitute authorization for it to perform the acts specified in the preceding paragraph. Part 8. Final provisions. Article 81. Signature. The present convention shall be open for signature by all states members of the United Nations or of any of the specialized agencies or of the International Atomic Energy Agency or parties to the Statute of the International Court of Justice, and by any other state invited by the General Assembly of the United Nations to become a party to the Convention, as follows: until November 30, 1969, at the Federal Ministry for Foreign Affairs of the Republic of Austria, and subsequently, until April 30, 1970, at United Nations Headquarters, New York. Article 82. Ratification. The present convention is subject to ratification. The instruments of ratification shall be deposited with the Secretary-General of the United Nations. Article 83. Accession. The present convention shall remain open for accession by any state belonging to any of the categories mentioned in Article 81. The instruments of accession shall be deposited with the Secretary-General of the United Nations. Article 84. Entry into force. 1. The present convention shall enter into force on the 30th day following the date of deposit of the 35th instrument of ratification or accession. 2. For each state ratifying or acceding to the convention after the deposit of the 35th instrument of ratification or accession, the convention shall enter into force on the 30th day after deposit by such state of its instrument of ratification or accession. Article 85. Authentic texts. The original of the present convention, of which the Chinese, English, French, Russian and Spanish texts are equally authentic, shall be deposited with the Secretary-General of the United Nations. In witness whereof the undersigned plenipotentiaries, being duly authorized thereto by their respective governments, have signed the present convention. Done at Vienna this 23rd day of May, 1969. Annex. 1. A list of conciliators consisting of qualified jurists shall be drawn up and maintained by the Secretary-General of the United Nations. To this end, every state which is a member of the United Nations or a party to the present convention shall be invited to nominate 2 conciliators, and the names of the persons so nominated shall constitute the list. The term of a conciliator, including that of any conciliator nominated to fill a casual vacancy, shall be 5 years and may be renewed. A conciliator whose term expires shall continue to fulfill any function for which he shall have been chosen under the following paragraph. 2. When a request has been made to the Secretary General under Article 66, the Secretary General shall bring the dispute before a conciliation commission constituted as follows. The state or states constituting one of the parties to the dispute shall appoint a. One conciliator of the nationality of that state or of one of those states, who may or may not be chosen from the list referred to in paragraph 1, and b. One conciliator not of the nationality of that state or of any of those states, who shall be chosen from the list. The state or states constituting the other party to the dispute shall appoint 2 conciliators in the same way. The 4 conciliators chosen by the parties shall be appointed within 60 days following the date on which the Secretary General receives the request. The 4 conciliators shall, within 60 days following the date of the last of their own appointments, appoint a 5th conciliator chosen from the list, who shall be chairman. If the appointment of the chairman or of any of the other conciliators has not been made within the period prescribed above for such appointment, it shall be made by the Secretary General within 60 days following the expiry of that period. The appointment of the chairman may be made by the Secretary General either from the list or from the membership of the International Law Commission. Any of the periods within which appointments must be made may be extended by agreement between the parties to the dispute. Any vacancy shall be filled in the manner prescribed for the initial appointment. 3. The Conciliation Commission shall decide its own procedure. The Commission, with the consent of the parties to the dispute, may invite any party to the treaty to submit to it its views orally or in writing. Decisions and recommendations of the Commission shall be made by a majority vote of the 5 members. 4. The Commission may draw the attention of the parties to the dispute to any measures which might facilitate an amicable settlement. 5. The Commission shall hear the parties, examine the claims and objections, and make proposals to the parties with a view to reaching an amicable settlement of the dispute. 6. The Commission shall report within 12 months of its constitution. Its report shall be deposited with the Secretary General and transmitted to the parties to the dispute. The report of the Commission, including any conclusions stated therein regarding the facts or questions of law, shall not be binding upon the parties, and it shall have no other character than that of recommendations submitted for the consideration of the parties in order to facilitate an amicable settlement of the dispute. 7. The Secretary General shall provide the Commission with such assistance and facilities as it may require. The expenses of the Commission shall be borne by the United Nations. The end.